everyone, my name is Margaux, and I'm from the Foundation for Individual Rights and Expression, also known as FIRE. How many of you all have ever heard of FIRE before? Amazing. Okay, so that's a good amount of you. And today we're going to be going over what speech is protected and what speech is not protected. In the U.S., we are bound by the First Amendment, and there are some limitations to the First Amendment as determined by the Supreme Court. So this is a fun little presentation that we have to kind of go over those limitations, and some of my colleagues have some stickers and other goodies that you will get if you participate. You don't even have to get the answer right, so don't be scared. Okay. The first category, well, it's a lot of speech. Never mind. Well, unprotected categories. Okay. Obscenity. Now, what counts as obscenity? So over time, there's been actually a few changes to what obscenity means, and courts have narrowed the legal standard for what constitutes as obscenity. So in a general definition, it's offensive but not obscene speech that is protected. Can anyone kind of give me what they think that the Supreme Court definition of obscenity is? Yes, Sam.
It is something that has no, how can I say, it is only intended to shock. It is art or no, or ballad like that.
Right, yeah, so you're thinking of the definition that we would use to allow for pornography in this day and age, which says that, we can't allow for certain art if it has value or something like that. So yes, you're giving a great definition. So this video from Gone with the Wind, I don't know if I'll be able to play it, but it's really funny because the final line in Gone with the Wind had damn in it, and the director was actually producer was actually fined $5,000 because that was deemed to be obscene when Gone with the Wind first came out. And we use this as an example because it showcases that over time, our definitions for what's obscene or what's not okay or what, we deem as uncomfortable speech in society really does change. So in our current standard for obscenity, we use the Miller test, which is what Sam was referring to. So whether the average person is applying contemporary community standards would find the work taken as a whole appeals to the prurient interest, excessive sexual content, whether the work depicts or describes in a patently offensive way sexual conduct, specifically defined by the applicable state law, and whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. Any questions on obscenity? Yeah, that's not one of the fun stuff. Oh.
Yes, I have a question.
Yeah.
So when the test was developed, people basically said that was bullshit. The First Amendment does not have such sweeping exceptions for free speech, which is interesting.
Yeah, absolutely. And today we hardly even use it, right? So we use the Miller test. Yes, I think we're on the same page, yeah. Now we're going to move to true threats. So we have a little example for you all. So Felicity Merriman is listening to All Too Well, the 10-minute version, at 1 a.m., and her neighbor, Kit Kittredge, lives in the next apartment. And Kit is instantly furious and reports this to their landlord. The next day, Felicity then tells Kit, "I can't believe you reported me, you snitch. I'm going to kill you with my gun at 9 a.m. on Wednesday when you leave to go to work. My music won't be a problem anymore because you'll be dead." It's very specific. Felicity is a known drug dealer currently awaiting trial. Kit is terrified, but is not sure if Felicity is within her rights of free speech. It's not, oh. There's the gun. I think it is. Is this protected speech?
No.
Correct. It is too specific. No. Good job, everyone. Our interns had a little bit too creative freedom with Canva this summer. So unfortunately, Felicity misses the release of 1989 Taylor's version because she is in prison, and then Kit becomes radicalized after her experiences in court. Now, kind of going into more of true threats. So Virginia v. Black defined true threats as statements where the speaker means to communicate a serious expression of intent to commit an act of unlawful violence to a particular individual or group of individuals. And speech becomes unprotected intimidation when it has the intent of placing the victim in fear of bodily harm or death. So emphasis on the actual intent and seriousness of the threat. So one example is we have from this lyric is, if I see you in the streets, bitch, your ass is done. This wouldn't count because it's not actually directed at an individual. There isn't some time or place, and it's just not specific. Whereas, in our prior example, Felicity gave a time and place, and, there was a reason for Kit to be scared as she was a drug dealer and she had a murder weapon. Any questions on this? Amazing. Oh, yes. Mm-hmm.
Say there was a protest and a counter-protest, and someone said something similar out of campus. Would that be considered a arrestable threat?
That's a great question. I think it would depend on if there were any weapons at play, if that makes sense. Like if the protester or the counter-protester had a reason to fear for their life in that statement, or if they were just saying hyperbolic expressions back and forth in order to intimidate or aggravate the other person. Does it make sense?
Yeah.
Cool. Incitement. So the Brandenburg Standard is that speech that is intended and likely to provoke imminent unlawful action. And so 1, it's intended to produce the action, and 2, it is likely to produce the action. And we're back with Kit, and now she's a commie. So Kit is back, and she is, a radicalized communist. Sorry, I spoiled it. She's in deep debt from her court fees and ready to overthrow the government. At a Communist Party of Cincinnati meeting, Kit drones on about leading a charge to overthrow the government. Weapon in hand, she says, if Biden doesn't send us more stimmies, we strap up and storm the Oval Office. Is Kit's speech protected? Yes?
Yes, because it is not likely that, is it going to, make people go to the Oval Office, and also because she's in, she is in, Cincinnati, and, Biden is in Washington. So it's not likely that, they would just drive all the way there just to invade the Capitol. So it's not likely to protect the speech, so it's completely protected.
It's also a great point. But anyone say no? Anyone think, yeah?
She has a weapon in her hand.
That's true, too. It does say weapon in hand, yeah.
She has a weapon in hand while she's making a threat, especially.
I was going to say, yeah, she's holding up a Glock or something yeah, we're going to kill him.
Yeah, so.
Yeah.
It still doesn't pass the evidence test. It's similar to the language preference.
Yeah. I am hearing a lot of debates across the aisle. Who's to say? Well, fire has to decide. So I will have to ultimately give you the answer. Is Kit's speech protected? It is protected. So Brandenburg, as we discussed, it's intended to produce action, and it's likely to produce action. Oh, okay. So you kind of can tell, but there's a little check mark above intended to produce action. So Kit really wanted to do this. She had the intent, but is it likely? There's an X. Most likely not. Yeah.
Is this what shouting fire is under? What was that? What's that called?
That's a great question. Yeah, shouting fire is under this, yes, as well. Yes. But shouting fire is protected speech.
So shouting fire in a public, in a crowded room?
It is protected speech, actually. It is from an outdated, yes, it is from an outdated precedent that no one really responds to anymore because it was used as a metaphor, in the court case. It was that would be like shouting fire in a crowded theater. Personally, not speaking on behalf of fire, I wouldn't recommend that you do that. I think that you would fall victim to cancel culture. But you are within your rights. You're within your rights to do it. that as well. But if you're just shouting fire, as in like fire, then that's totally chill. Anyway, back to Vandenberg. It's intended to produce action, and it is not likely to produce action. Kit was making grand propositions that required theoretical events to happen before any real action would be taken. This all makes sense? Amazing. Harassment. The case. Anne, okay, we're moving on from American Girl dolls. Okay. Anne is walking on her campus, and a complete stranger named Jimmy, out of nowhere, exclaims, "You look like Carrot Top." This is Carrot Top for reference. Anne is devastated by this comparison. She is so distraught by this that she is unable to focus on her classes for the rest of the day. As Anne walks home, thinking her day cannot possibly get any worse, she walks past Jimmy again, who excitedly says, "Hey, it's Carrot Top." Anne breaks down in tears on the sidewalk. Is Jimmy's speech protected? You'll say yes? Anyone say no?
I would say yes. I mean,
Could be a compliment in his book.
Fair?
It is not like super pervasive either, which is why super pervasive.
It's fair. All good points, all good points. Anyone say no? Anyone say it's not protected? Okay, no fighters on the other side. Harassment. So according to Davis v. Monroe, to be considered unlawful student-on-student or peer harassment, behavior must be unwelcome, directed at an individual, discriminatory on the basis of a protected status, like gender or race, and so severe, pervasive, and objectively offensive that the victim is effectively denied equal access to the institution's resources and opportunities. So I would say that this is unwelcome, and there's a check mark right there. It's black, sorry. It is directed at an individual, but is it discriminatory? No. That would be a really interesting case, and I would not be surprised if we see that in a few years, but no, it's not a protected status. And is this severe, pervasive, and objectively offensive? Nope. So it does not meet those standards for harassment, and thus Jimmy's speech is protected. Fraud. So basically, long story short, fraud is false speech employed for commercial gain. So Kit, we're going back there again, has radicalized her son. She's old now. She's radicalized her son, Jack Jr., and Jack dodges the draft. He wants to sell Cincinnati Mayor Jerry Springer a car. And then to convince Jerry, Jack says, "Back in Nam, I got the Purple Heart saving 2 guys." Jerry gets him indicted for stolen valor. Is this speech protected? Does anyone have any thoughts? I see some yes. Anyone want to say no? Some people are just confused, and that's okay too.
What is stolen valor?
For lying about being in the military service.
if you portray yourself as like some military hero and you were never even military, you go to jail.
You can only receive valor when you're
It's protected. It is protected. Laws must be narrowly tailored. So one example of this is the American School of Magnetic Healing versus McNulty. And the American School of Magnetic Healing was basically sending pamphlets in people's junk mail and saying that they could heal people through magnetism and sort of new wave healings as such. And they their speech ended up being protected. Their postmaster general actually tried to stop that speech, and it said that the Post couldn't actually do anything about it. They were allowed to send their flyers through the mail. But Jack is acquitted on stolen valor on this, as the Stolen Valor Act is unconstitutional, but he never sells a car again. He later goes to jail for insurance fraud, which is in fact illegal. Defamation. Okay, so defamation, I know that's kind of a hot topic right now. So it's a false statement presented as fact, If it's in a publication, if it's printed, it's libel, and if it's spoken, then it's slander. And a third party must recognize the defamatory material is about the plaintiff. So you have to have some third party involvement. The defamatory meaning, so the speech harms the subject's reputation. There must be falsity. The plaintiff must prove the speech was false, and then the plaintiff must prove the defendant was negligent, knowingly published false statements, or acted with reckless disregard for the truth. So in our case, we're looking at YouTuber Tasha K. She published a series of videos about Cardi B. She falsely stated that Cardi had contracted herpes, been a prostitute, cheated on her husband, yeah, that works too, and done hard drugs. And none of this was true. Is Tasha K's speech protected? Correct. Oh, well, we're just going to move on to fighting words like that. But you guys are absolutely correct. So going back to the standard, the speech, we can look at it. Did it harm the subject's reputation? We could argue that Cardi B's reputation wasn't harmed. You'd have to know that the speech was false when you're saying that. And even if there was some fault to it, you'd have to meet all three standards. Fighting words. Okay. So word about the Felicity Kit conflict spreads, and Felicity's friend makes a statement saying Kit's family deserved the Great Depression. Is this speech protected? Yeah. Does anyone say no? It is protected. So one man's vulgarity is another's lyric. The Constitution leaves matters of taste and style so largely to the individual, and this is from Cohen v. California, where we had someone who was protesting the draft with a F the draft jacket on his jacket. And this was a really big case at the time. It still is. It's a wonderful precedent for being able to speak freely. Yeah, we're going to go into child pornography. That is a great time for someone to step in and film. No, you're fine. It was just got me a little off guard. Okay. Yeah, that it really is. It's going to look great for fire. Okay. So I'm not going to have anyone guess anything for this. That's important. Let me just lay those ground rules. So the Miller test for obscenity is not absolute. And when you talk about child pornography, I do want to make it very clear it's a crime, as well as it's also under unprotected categories of speech. But we do have a few Supreme Court precedents and prior court precedents that do discuss it. And the court has previously struck down two provisions to the 1996 CPPA Act and Ashcroft v. Free Speech Coalition in order to protect children. And it is interesting when discussing some of the definitions because, for example, under some of the more strict definitions of child pornography, this ad for Calvin Klein jeans in the early 2000s would not be allowed. So I'm not going to go super in depth into that. Some of our lawyers at FIRE would be more than willing to kind of discuss that and how it relates to free expression, but that is one of the unprotected standards of speech. So common misconceptions. Hate speech. Hate speech, what is it? Hate speech is speech that offends, threatens, or insults groups based on race, color, religion, national origin, sexual orientation, disability, or other traits. And this is a definition from the American Bar Association, but it's not a legal definition. And that's really important because we don't have a legal definition of hate speech in the United States. Other countries with a similar legal system to the U.S. Have definitions of hate speech, and you can be tried for certain types of speech that would fall under that category in those countries. But we do not have that in the U.S. There's never been a case with any sort of legal definition of hate speech here, and there are other groups that do have some sort of definition or whatnot. But hate speech is protected in the U.S. And as we've kind of talked about, another man's vulgarity is another man's lyric. Something that you might find hateful or that you hate is might not actually offend another person, even if you are in the same protected status or something like that. So the legality of hate speech, one example. So in Skokie v. Illinois, the town of Skokie was sued for denying a permit for allowing the National Socialist Party to march in a heavily Jewish neighborhood. And the ACLU actually defended them. And the public expression of ideas may not be prohibited merely because the ideas themselves are offensive to some of their hearers. So hate speech in and of itself is protected by the First Amendment and doesn't have a legal definition. Another common misconception is the heckler's veto. So the heckler's veto, what is it? Well, it's not protected, that's what. And heckler's veto occurs when someone wishing to prevent someone else from speaking threatens a breach of the peace, or it disrupts public order if the speaker continues speaking. Sometimes authorities, rather than discipline or arrest the heckler, remove the speaker or cancel the event. For some of the college students in the room, I'm sure you've had events at your campus where other students have prevented speakers from, professing their First Amendment rights to speaking. And at FIRE, we love protesting, we love counter-protesting, but we also want to make sure that speakers are able to express their own First Amendment rights as well. Yes?
So if we have, for instance, George Mason University during their club work, I was tabling with the Students for Life chapter, and we had someone come up and actually had called compliment twice for harassment.
Wow.
Because she spent an hour and a half yelling at us. Could he potentially, he got in trouble for harassment. But if an organization is tabling and is trying to speak to people,
Right.
could that technically be under heckler's veto or just under harassment?
That's a really great question. I think that would depend on the venue and also depend on the specific policies, because George Mason University is a it's a public university. Okay, I'm gonna stop on that. Then I think it potentially could be a heckler's veto. Yes, because if it's preventing you from enacting your First Amendment rights on your campus and it is public, then I think it could. But they could easily use the defense that they are counter-protesting and they're engaging with their First Amendment rights critically by talking with you all, but you could also say, like, we're unable to share our message and table in the way that we were allowed to. Oh. Then that's... That's a lot of heckling. It's a lot of heckling that he was doing. Yes, then I would say that would fall under not what we would traditionally consider a heckler's veto, but some version of it, because he is attempting to remove the event from happening. In prior case law, Termineo v. Chicago, speech fulfills its high purpose when it induces a condition of unrest, creates dissatisfaction with conditions as they are, or even stirs people to anger. I think that's very powerful. So one case that we kind of like to do, we've already kind of talked about the legality of it, but FIRE comes to your campus to talk about free expression. You gather with your friends eagerly in the auditorium. Protesters begin to shout down the speaker after the event starts. The counter-protesters are given a chance to read a prepared statement but continue to disrupt. You gather with the FIRE speaker in a smaller circle to hear them speak, but the protesters gather around you. Your school administration cancels the event due to the protesters. Is this protected?
Okay, if the school's private, they have the right to cancel whatever event. If it's public, I'm gonna say no, because I would feel that the burdens fall on it falls on them to provide security and not just cancel the event.
Right, I think that is absolutely fair. If it's private, they could cancel it. They could cite it as a security issue. But also, if you went to a private school and they canceled this issue and say they only canceled FIRE, but they had another organization and they had a similar heckler's veto, but they were able to bring them to a smaller venue, you know, then we could even talk about viewpoint discrimination or something like that. You know, so if, you know, you had a lot of right-wing groups come on campus and they were heckled out and your school didn't reschedule them, but they rescheduled left-wing groups, or they were able to provide left-wing groups those space, that's something we'd want to look into, public or private, because that could be an example of viewpoint discrimination. So yeah, that's a good counterpoint.
Is I mean, like, is like viewpoint discrimination prohibited in private colleges as well?
No, it is something that we do at FireThink sets a bad precedent and doesn't create a culture willing to support academic freedom or free expression or helpful to students' ideas. So if we ever engage with a private college, we kind of like to point out the hypocrisy of viewpoint discrimination, though. Yeah. Absolutely. Yes, it's not protected. And counter speech is okay, but preventing a speaker is not. Any questions? Yeah.
So you were talking about the defamation cases, and I have a question. I heard the defamation laws, it varies by like state. So for example, some states they have some differences between, like, for example, like a private and a public figure. Some other states they say you have to prove that there was like malicious intent, and like some don't. Some states put the burden on the plaintiff, the other the defendant. So like, is that true? Is it? I mean, how can I say? Is it like? I mean, like, how can I say? Is it like by state, or is it like a national defamation law?
Right. So there is Supreme Court precedent for defamation, but I cannot speak to what would happen state by state if someone was going to sue someone in Maryland versus if someone was going to sue someone in Maine. I'm not an expert on defamation. Yes. Any questions? Yeah.
First of all, thank you for a very interesting presentation.
Oh, thank you.
Fire for a lot of good work. Fire was very helpful at the University of Virginia. What is the status currently of speech codes? Because they seem to have a high watermark. Many universities have now gotten rid of their speech codes or made them much more liberal in a good sense of the term.
Yes.
Fire assess the sort of the general status of
We'll have this be the last question then. That is a great question, and I will say that thanks in large part to Fire's work on campus, we actually have worked with a lot of administrators over the past 2 decades of Fire being around. You're speaking as if you're familiar with our policies of red light, green light, yellow light. We've moved a majority of schools from red light to now yellow light. So a majority of schools that we measure are now in yellow light, which means they might have iffy codes, but they don't prevent free expression in general, which is where we like to see. And we have a whole booklet of our free speech policies or free speech codes that are ranked back at our little table. So we're actually very happy with the status of speech codes compared to what they were 10 years ago. I'm not saying all across the board, but definitely compared to, and we find administrators are a little more intimidated of our work now. So yes, thank you for asking. Thank you. Oh, sorry. Yeah. Okay.
I have a question. So do you find that younger instructors and students are more likely to favor restrictions on academic freedom and freedom of speech in general, whereas older professors like, support the idea of academic freedom like more?
Yes, absolutely. That's correct. I find that, yeah, exactly what you said. Yeah, younger students, younger professors, more likely to be in favor of more restrictions.
Why do you think it is a phenomenon?
I think it's a cultural shift, and I think that there can be a lot of reasons for that. Our CEO wrote a book called The Coddling of the American Mind, and he talked about how my generation and the millennials and, you know, kind of Gen Z, we kind of began to equate physical safety with emotional safety and the need to have emotional safety codified in some of our school policies. So I'm sorry to cut that short, but we can talk more free speech at our table over there, but I don't want to cut into the main stage programming or the next program. So thank you all for listening.